All right, we'll go ahead and get started. I want to welcome everyone to the House Judiciary Committee. We have several pieces of legislation on the agenda today, and I will mention that we are planning to add Senate Bill 120 to the 6 bills that we previously had on the agenda, just so everyone's aware that that bill is also going to be taken up today. So we will go ahead and get started this time. We have a quorum, and I will call up Senator Dixon. Senator Dixon, if you'd like to come forward and present Senate Bill 33.
Thank you, Mr. Chairman, committee members. I bring Senate Bill 33 before you today. This bill has to do with human trafficking. This is a governor's bill and a continuation of the First Lady Marty Kemp's initiatives. I'm honored to be bringing this piece of legislation before you. This is an issue that touches my county and many of yours, and will be crucial in helping further protect these helpless or vulnerable victims of human trafficking. It first creates a new code section provided for victims of human trafficking to have civil cause of action against a perpetrator. Secondly, it allows victims to potentially recover damages and reasonable attorney's fees. And then third, it creates a statute of limitations for filing such civil action and allows for a stay of the civil lawsuit while any criminal action arising from the incident of human trafficking is pending. It also allows for the Attorney General to have cause of action against a perpetrator of human trafficking on behalf of the state under certain circumstances.
All right. Thank you, Floor Leader Dixon, for your presentation. Any questions for the sponsor? All right, I don't see any. We have had some questions just about potential applicability, and I'll just share with the committee the back and forth that we've had with through a member of our committee in contact with the governor's office about this. But our questions were, first of all, would this bill be only applied prospectively, or would there potentially be a look back that would be part of this legislation with the 10-year statute of limitations? And the response given was that it was felt that this would be prospective, just as it's written. Some very smart attorneys who give us great advice have also offered the belief that they do believe it would be prospective, but there have been some opinions offered that there would potentially be retroactive applicability as well. So I'll just raise that for the committee to be aware of here today, and we can discuss that if it's necessary to do so, if you feel it's necessary to. The second is to the cause of action for the Attorney General, which is covered in lines 28 to 31. That, as I understand it, that language tracks from some federal law that the governor's office had reviewed and wanted to include. I believe I have that right. But in any event,
yes, sir.
The intent was for the 10-year statute to apply there as well. As I read it, I don't think it does, with lines 28 to 31 not being identified in D, statute of limitations. But nevertheless, I don't know that that's problematic when we have such an important issue as we're considering as this is here. Anti-human trafficking measures have been passed unanimously or close to for the past several years with the important public policy of addressing these heinous crimes and ensuring that Georgia stands out as a model state for how to address these terrible crimes and criminal enterprises. And we're grateful for the First Lady and the Grace Commission for the work on this issue. Floor Leader Dixon, any comments you want to give about any of those issues or anything further you want to say?
Yes, sir, Mr. Chairman. I mean, you covered it well, talking with the governor's office, but this statute, it does mirror the current federal statute that's in place. And there's no mention to any look back. understand the concerns, but there's no mention of it in here. So the stance that the governor's office has taken that would not apply in this legislation.
All right. Any questions from any members of the committee? All right. We don't have any online. Well, I'll hear a motion if there is one. There's a motion to pass and second. All right. Any amendments, further discussion? Hearing none. All those in favor signify by.
Aye.
Chairman Rich, did you have any questions or amendments?
No, I did not.
All right. Very good. So all those in favor signify by saying aye.
Aye.
All right. Any opposed? Very good. Well, Senate Bill 33 passes unanimously. It's on to Rules Committee, and we want to expedite this getting there. So if you want to complete a Rules Committee form, Leader Dixon, we'll go ahead and get that signed so you
Thank you very much.
get that submitted
Absolutely will.
immediately. All right. Have a great day.
All right, you
Thanks
too,
for
sir.
being here.
Thank you.
All right, very good. So we will next move on to Senate Bill 200. Would you mind checking to see? And while our Senate sponsor is coming in, we're very honored to have with us here today Judge Burt Guy from St. Mary's, Georgia, Superior Court Judge, who's with us. Judge, it's great to see you today. Thank you for being here. Chairman Fleming used to say, if anyone gets out of hand, maybe you can advise on contempt powers here in the committee room. No, it's great to have you, Judge. Well, all right, we'll go ahead and call Senate Bill 200 up next. And Senator, if it's all right, maybe I can give a kind of a summary of what changes have been made since this bill was last before the committee. Would that be okay?
Yes, Mr. Chairman. Thank you. Good afternoon.
Well, good afternoon to you, and thank you for being here today. So really on the chairman's prerogative, following the discussion that we had last time, Mr. Myers and I have spent quite a bit of time going through what potential modifications or draft would be appropriate to get legislation moved. And what we've done is in section 1 of the bill before you, and this is LC 413117S, we've incorporated the language from Floor Leader LaRiccia's bill that passed out of committee previously. And that's the only language there in section 1. So that passed previously out of House Judiciary. In section 2, what we did is we took the language from Representative Carpenter's bill, which was actually very close to the language in the Senate sub that we saw before, and we updated it reflecting some of the concerns that Representative Stacey Evans had. And she is out today. She is out of town, and I was texting with her, but she did have a chance to view this yesterday. I don't want to speak for her, but I left our encounter feeling like the issue had been addressed and everything was fine with respect to section 2 here. So in any event, that's what we've done. Would be happy to try to answer any general questions members of the committee might have. And Senator, is that a fair kind of summary of what's brought us to this point with this substitute?
Yes, Mr. Chairman. Thank you for your work and the committee's input to get to this point.
All right, very good. Thank you. Representative Oliver, Chairman Oliver.
Senator, with these changes, do you have an opinion that you could share with us how this bill changes the law as set forth from the United States Supreme Court?
I mean, I think currently as this law is written, as the chairman has put together, I think this lines 13 and 14, I think, are in line with what's been brought before the United States Supreme Court.
Do
And if
I,
I'm mistaken, I'll let y'all
do
correct
I interpret your answer to mean that it does not change the law, that isn't exactly what the United States Supreme Court said?
me. I think it is in line with what the Supreme Court has said.
So we are passing it for what reason then?
I think what we were doing is trying to make sure that we don't have overreach in this state, anytime there is a declared state of emergency in Georgia.
Any other questions? All right, seeing none, I'll hear a motion if there is one. Is there a second? Motion to pass and second on Senate Bill 200, substitute LC 413117S. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? In the opinion of the chair, the ayes have it. The bill passes on to rules. If you would just complete a rules committee request form, I'll go ahead and sign that.
Thank you, Mr. Chairman.
Thank you. All right, next bill on the agenda is Senate Bill. All right, there are two related bills that, well, one resolution and one bill that are on our calendar today. Those are Senate Bill 218 and Senate Resolution 134. And these bills came through subcommittee, and Chairman Walker's asked me to carry them. So I'll just provide a presentation for you here today. Be happy to answer any questions. We'll start by just covering the Georgia Constitution currently in a circumstance where a statewide elected official or a state elected official is suspended from office due to felony indictment. The official would continue to receive his or her pay related to the office during such suspension. And the Senate resolution, that's SR 134, would suspend the compensation under such circumstances. And then Senate Bill 218 is a similar issue as it relates to local elected officials. So if there was a circumstance where a local elected official were to be suspended from office, and this is because of a felony indictment, where again the process is, I'm just giving the brief overview here, that a panel is appointed to determine whether or not the felony indictment is related to the public officer's position and office. And then if it's determined that it is, then the official is suspended by that 3-member panel pending ultimate resolution of the case. And so under those circumstances, it's the legislation that's before you here would suspend the payment to that compensation to that official during that period of time. Now, we went over this in the Gunner subcommittee. Is there anything you want to add, Chairman Gunner?
I will say that in Senate Resolution 134 that it's very limited as to who it applies to: governor, lieutenant governor, secretary of state, attorney general, state school superintendent, commissioner of insurance, commissioner of agriculture, commissioner of labor, and any member of the General Assembly. So it doesn't include like your Superior Court judges and that are considered state elected officials. So that's really all it applies to, and it received a due pass in committee.
Thank you for that. And thanks for clearing that up. That, very specific offices that each will apply to. All right, any questions?
Yeah,
Yes, sir.
I got one. I can't find that thing on here to raise my hand, but wouldn't this, violate the concept of innocent until proven guilty? To punish the person for something that they've been accused of but not convicted of.
The issue here is not that they're being punished. It's that the compensation is just suspended while the suspension is in place. And there actually it allows for recovery of that suspended amount if they're ultimately exonerated, found not guilty. So in light of
Okay.
that, do you still have
I
concern?
hear what you're saying, but we can call it a duck. That don't make it an elephant. The reality is that the person is being denied their pay, before they were convicted of anything. And what do they need to pay for their legal defense? I mean, I'm just asking us to vote to convict somebody or to punish somebody before they're convicted.
The key word, Mr. Chairman, would be indicted. Is that not right? Not just accused, but indicted.
The Chairman Scoggins just said the key word would be indicted. I would agree there's due process protections in that a grand jury would have to return an indictment, and also the panel of 3 would have to agree to put the suspension in place. I'm going to recognize Chairman Oliver and then Representative Wilson.
Representative Bruce, you've raised a question that is a relevant question, and particularly from the DeKalb County experience, CEO Beryl Ellis was convicted and went to jail, and then his conviction was overturned and he was not prosecuted again. And during that period of time that he was in jail, he was legally innocent. The difference, though, is you're not entitled to a job. You are entitled to freedom, but you're not entitled to a job. And therefore, to me, there is a very significant difference, constitutional difference, between the 2 points you make. But Beryl Ellis has been in my mind as I've thought about this bill, and I still support it. Thank you.
Representative Wilson.
Mr. Chairman, I have a comment and then a question. I agree with Chair Oliver that I think that this is a needed pieces of legislation. And in particular, I've been mindful of the fact that we're paying 2 insurance commissioners right now, one of whom is under indictment and suspended. And part of my question is, how does the suspension process work? Is it automatic, or is there discretion not to suspend someone under indictment? I'm just not familiar with how the process works.
If I can direct your attention to the language of the legislation before us, I think when the felony indictment's returned, there's a very specific process that is to be followed, but it depends upon the officer involved. So there's a different panel that would be impaneled depending on who the subject of the indictment was, and then based upon what the recommendations are, I believe it's within 14 days the panel has to act, and based upon a suspension at that point. Am I answering your question?
You are, and I think this gets back to Representative Bruce's question or point, that the fact that the individual has been suspended from office, they are no longer performing the job functions. And therefore, if we're looking out for the taxpayer's dollar, knowing that we have to, for example, in the case of the insurance commissioner, we've had to appoint someone else to fulfill those duties while the elected official is taking care of their criminal matter. It makes sense to suspend the pay as well.
All right. Any other questions? All right. I will first, as to Senate Resolution 134, hear a motion. So move to pass. Is there a second? All right. Motion is second. Any further discussion? Hearing none. All those in favor of Senate Resolution 134 as passed in the Senate signify by saying aye. Any opposed? All right, passes unanimously. Next, as to Senate Bill 218 as passed in the Senate, is there a motion? There's a motion and a second. Any further discussion? Hearing none. All those in favor of Senate Bill 218 signify by saying aye.
Aye.
Any opposed? All right, it passes on to rules, unanimous. If Senator Kennedy or Senator Tippins can hear me, they can come on in the committee room. Otherwise, we will move on to another bill I'm presenting. All right. So, Senator Tippins, thank you for being with us here today, and we'll go ahead and call your bill up right now.
Thank you, sir.
So, Senate Bill 120 was not on the calendar initially today, but it has been handed out, and there is going to be, fair warning, there is going to be there is going to be an addition to that we'll be discussing in just a moment, but we'll first let Senator Tippins present Senate Bill 120. Thank you, Senator.
Okay.
Go ahead and proceed when you're ready.
Thank you, Mr. Chairman. Senate Bill 120 mirrors an existing provision in state law that created the Office of District Attorney Emeritus. This is exactly the same language as applied to district attorneys, but it's crafted specifically for those individuals who served as Solicitor General. It has the same service requirements, 20 years as a prosecuting attorney in the state court and a Solicitor General. And there is no financial impact on this. This is just an honorary office or title that's conferred on those that have served our counties well. I think there's 22 judicial jurisdictions in the state that have state court circuits, and this would apply to them. My understanding is the individual who has the most service, and I'm sorry I don't know his name, but he has Appleton County and Jeff Davis County, Baxley and Hazelhurst, Georgia, and I think he either currently has 24 years or I'm not sure, but my understanding is he's pretty much the dean of that group of solicitors general.
Very good. We have a few questions.
Yes,
Chairman Gunner.
Senator Tippins, I like your bill, and but I just have one question about it. The Solicitor General Emeritus has, as it says here, served as a prosecuting attorney for 20 years. So they could start out as a Solicitor General and then end up as a DA and qualify for this. Would that work?
My understanding is as long as they have served as a Solicitor General and they have been in the office and served as a prosecuting attorney for 20 years.
Okay. So it wouldn't matter if they were DA or Solicitor General.
I wouldn't think so.
Okay. All right. I think it's a good bill because they would qualify under both systems is what I'm reading.
Well,
They could be either Solicitor General Emeritus or DA Emeritus.
well, I hadn't thought about that, but I think in our local situation, we do have folks that go between the solicitor's office and the DA's office,
Okay.
or have gone. So,
Thank you, sir. I
yes,
appreciate
sir.
it.
Thank you.
And Chairman Gunner, do you have an opinion as to whether a prosecuting attorney would include, say, a solicitor in a municipal court or someone outside of?
I think under our law, it would qualify.
All right. Any questions for Senator Tippins? All right, seeing none, well, thank you very much, Senator, for being here today. And What we're going to do is Chairman Barr has a proposal that he would like to append to your bill. And so we're going to suspend Senate Bill 120 for the moment, but I anticipate we'll be taking action on it today.
Okay.
So you're welcome to stick around or go as you choose. So
I need to get a bill out of government oversight at 2:00. But
you are
if-
excused.
If
Yes, sir.
y'all would, give me a copy of the change, if you would forward it to my office, I'd appreciate it.
We will be happy to do that.
Thank
Yes,
you
sir.
so much. I
Thank you,
appreciate your
Senator. It's
communication.
great to
Thank
see you today, sir. So Chairman Barr, if you'd like to come on up here in the witness chair, we will go ahead and hear from you. Of course, please. So just for the committee members' benefit, while we're continuing our discussion about Senate Bill 120,
Yes, sir.
Chairman Barr is presenting to us what is marked in your folders as a substitute to House Bill 736. Substitute to House Bill 736. All right, Chairman Barr, we'll
All
recognize
right.
you now.
Well, what we have today is quickly a little bit of background. The Office of Inspector General is currently only a executive order. It has been under an executive order since Sonny Perdue in 2002, I believe. And they investigate waste, fraud, abuse, and the sexual misconduct under our state agencies. Currently, they don't have post certification. So this bill seeks to do two things: make them more effective with a post certification, and then create them in code so that they would not be dependent on the continuing executive order. So that's a high level view of what the bill does. Would it be okay if Miss Bethany spoke to it briefly as well?
Absolutely, ma'am. If you just identify yourself and actually, would you please shift over here to the microphone? You're fine.
Okay.
Yeah, if you'll we have this set up for social distancing. If you'll come over here to
I'm
this.
so sorry.
You're fine. And if you would please just confirm that's number 5 on the sheet in front of the mic.
Yes.
Great.
Correct.
Yes, ma'am.
Hi, my name is Bethany Wetzel, and I'm General Counsel for the Office of the Inspector General. Thank you so much for the opportunity to speak. Really appreciate it. As Chairman Barr stated, currently the Office of the Inspector General is an executive order agency. I believe we are the only executive order agency currently enacted. Other agencies that have been created through executive order have been codified. And so we're seeking that same status. So the bill, the main purpose is, one, to codify us. Second, is to increase efficiency within our office, to be able to hire post-certified employees and to have peace officer authority to be able to get warrants and to be able to get subpoenas. It has to be done through legislation, can't be done by virtue of an executive order. So one way that it'll increase efficiency in our office through being able to actually hire post-certified officers is that our officers will not have to rely on either GBI agents to accompany us to court to seek warrants in our investigations. And then also it will enable us to issue subpoenas without going through the Attorney General's office. We currently have a very good relationship with the Special Prosecutions Unit in the Attorney General's office. And so generally, if we need a subpoena, we have to go through them to get that information. And then if we want to seek a warrant, we have to we tie up a GBI officer sometimes for several hours a day trying to seek warrants. And so what our office does, why it's so important for us to be able to get warrants and to have subpoena power, is because a large bulk of the investigations that we complete are financial investigators. We have forensic accountants on staff. We have certified fraud examiners. So a lot of times when we're trying to recover money for the state or to detect fraud, we're doing a bank analysis review. So to get those bank records, generally a suspect is not going to turn those over to us freely. So we need to get those through either a warrant or through a subpoena. Additionally, our office investigates conflicts of interest, ethics code violations, violations of the governor's executive ethics order. So those are just some things that our office does. And then in 2019, when the governor signed his executive order on preventing sexual harassment within state agencies, the investigation and oversight authority was given to our office. And so that's a dual mission that we have, along with investigating fraud, waste, and abuse within state agencies.
Few questions, Chairman
Okay.
Gunner.
Thank you, Mr. Chairman. I understand y'all have a dollar figure on how much y'all saved. Is that right?
Yes, and so generally our return on investment is in the millions. So our office operates at approximately like 1.3. Our budget is 1.3, I believe. In the last years, our return on investment has been, over $7 million. The fraud that we detect. So it's really important for us, especially when there's been fraud committed against the state by a vendor or an outside party, especially now with the sophistication of phishing attacks and the scammers. They're able to manipulate the system and pretend to either be a vendor or pretend to be a state employee. It's really important for us to be able to recover that money really quickly. And so one of the ways we're able to detect it is through subpoenas and warrants, and to be able to get that information and to identify those individuals so we can recover that money. Because our goal at the end of the day is to recover as much money as possible and to get any bad actors out of state government that we can.
Chairman Oliver.
I support codification and I support the post-certification. There's 6 pages of language here, though, that I haven't read. Where did this come from? And do I need to read it? I mean, are we worried about is this the operational format existing now, or tell me what's different?
So yes, ma'am, the language of the bill is by large the language of the executive order that's in place. However, the 2 main differences between the executive order that's in place currently and the language of this bill is, one, it would allow us to employ peace officers, so we can be able to get warrants, and then also for the safety of our officers when the safety of our investigators, and even me when I go to conduct an interview. And if we're dealing with, a hostile witness of some sort, it's nice to have an armed individual with you. So that's one difference, is the ability to employ peace officers. And then the second one is the ability to issue administrative subpoenas.
And everything else, all this other language exists today in the executive order?
By and large, yes, ma'am.
I will tell you one thing that we did add as we looked at it. It appears currently that the lottery was left out, and being the large amount of money that surrounds that, we did firm that up and add that in.
Representative Walensky.
Thank you, Chair. My simple question is just fraud, waste, abuse, and corruption. I understand that seems to be a common term. What is an example of waste?
So an example of waste would be an agency who is hosting a conference. And when they are putting on the conference, they are choosing a hotel that is very nice. They may be there may be federal grant dollars to pay for the registration of individuals, and they're not prioritizing state employees. They might be prioritizing individuals that are outside of the state. And so that's an example of waste, where there are ways that an agency could have been more fiscally responsible in the way that they administered funds that they were given for a certain purpose.
That sounds great. Thank you, Chair.
Chairman Burchett.
Thank you, Chairman. Chairman Barr,
Yes.
how is currently the Inspector General chosen?
That's a great question. The governor appoints that position, and it serves at the pleasure of the governor. We have been blessed to have. We've had longevity, and there's only been 2 in the last 19 years. But that's a great question. They are appointed by the governor.
Would you be open to a friendly amendment to add the line subject to the confirmation by the House and the Senate? So appointed by the governor, but subject to the confirmation by the House and the Senate. It would be on lines 41.
I'm not sure that the House confirms anyone currently. Traditionally, that's left to the Senate, but whatever the will of the committee.
My thinking was, I know we confirm, for example, the House and Senate Judiciary Committees confirm the state business court judge. I think it maybe makes sense. We have confirmation by the House and Senate Judiciary Committees. Would that be agreeable, Chairman Barr?
If that's the will of the committee, I don't stand in the way.
Any other questions for the sponsor, Representative Wilson?
Chairman Barr, how is the salary for the Inspector General determined? I don't see it anywhere in this bill.
That is something I do not know. Bethany, do you know that?
It's determined by the governor's office.
Okay, so it would come. It's not a separate.
It's not.
It won't be a separate department in terms of the budget. It'll be under
Correct.
the Office of Governor. Okay.
Do we know that there is no fiscal impact, which would require further analysis before passage?
There are some costs associated with post certification. We have added some of the cost in with our current budget, such as a vehicle. So that is narrow, but at this point, we wouldn't have to fund this, right? So we're not mandating anything. Correct me if I'm wrong.
So I believe there would be some initial cost of, I believe it's $12,000. I apologize for not having that. I have a detailed spreadsheet with that information that would provide for weapons and equipment, nothing major, a duty weapon and, a jacket. And then also we currently have 2 members of our staff that are post-certified. So one of those individuals would go to chief training because that's what is required to have a law enforcement unit within an agency or a department. And then the 4 remaining staff members would also need to attend post-training. But again, that's offered through GIPSTIC. And so that's a free expense. The expenses related to that would be just travel, room and board for that period of time that they would be getting training. And then annually, it would just be the retraining fees, which is very minimal, around $1,000 a year.
We are late in session right now, and I know Chairman Barr has a meeting today, so I don't want to keep him too long. But I do think right now it'd be helpful if there is any discussion. We're going to hold this right now and look at this issue a little bit further. But I think it's helpful if we briefly have some discussion about this. Chairman Barr had a bill that didn't make it by crossover day. We got another bill dealing with law enforcement and the Solicitor General's, but it's the committee's determination in the House ultimately as to the 2 subject matter issue. And so happy to hear any thoughts about that, and also the specifics of the idea and whether it might include a friendly amendment requiring confirmation of the office by the House and Senate Judiciary Committees. Any member of the committee want to speak? Well, I don't see anyone. Thank you very much, Chairman, for being here today. Thank you so much, man, for coming by. I think the committee fully understands the issue and look forward to being in further communication with y'all.
Great. Thank you
so much. Thank you.
All right, Chairman Kennedy, Mr. Kennedy, if you'd like to come on up. Yeah, well, I'm going to table Senate Bill 120 for now. So, Mr. Chairman, Senator Kennedy, great to see you today, sir. And
thank you.
At your convenience, please go ahead and present to us Senate Bill 234.
I'm happy to. Thank you, Mr. Chairman, for hearing from me and your committee considering Senate Bill 234. Also want to thank the subcommittee that heard the bill yesterday and the time that y'all put into this. I'll be brief if that's okay. And
yes, sir.
Direct me for more detail that the chair may desire or anyone on the committee. But this bill comes to you and is probably rather familiar. We had it last year. It is the Uniform Mediation Act. 3 reasons I think we need this legislation is: number 1, for legal consistency and clarity; number 2, to promote consumer protection through disclosures; and 3, to enhance and maintain Georgia's leadership in this area. There's concerns because we don't have the structural framework in our statutes for mediations. And so that is producing this lack of consistency and clarity. It also is causing, as a net of that we're missing some opportunities in the business world. And we heard from testimony in the subcommittee yesterday, particularly those lawyers that practice in the area of international mediations, that Georgia is being bypassed for some of our sister states to be the host site, because in the event that there were disputes, there's simply not the framework in the statutes right now that could resolve that. So we need to get those folks coming to Atlanta and the rest of Georgia to do those type activities for those type mediations. Highlights it brings, as I said, it brings certainty where we don't have it. It also addresses issues of privacy. And the one thing I'll point out that is different from the bill last year, and this came as a product of some concerns with regard to whether or not confidentiality would be absolutely maintained, or under whatever circumstances there might be some impairment of that. Lines 154 through 159 were added to the bill that was proposed last year. And it is my understanding that all the constituencies that had input in this are now pleased with what I'm bringing to you for consideration. We also had folks from the bar yesterday, from the dispute resolution section of the bar. And from my understanding across the board, everyone supports this. It has had a hand in it, and I offer it to you for that same consideration. And appreciate your time, Mr. Chairman.
Chairman Scoggins, this receive a favorable consideration in your committee?
Yes, sir, it did. We had members of the state bar here yesterday, and we talked and discussed the bill, and we felt like it was a good bill. And thank you, Senator Kennedy, for bringing it.
Thank you, Chairman.
Very good bill. All right. Any questions for the sponsor? Seeing none, I'll hear a motion if there is one. Move to pass in second. All those in favor of Senate Bill 234 signify by saying aye.
Aye.
Any opposed? Very good. Passes on to rules. Senator, there is a, you may already be aware of this, but there's a House Rules Committee form which is required to get your bill on. We have them in the Judiciary office here, and it requires that I sign it. If you'd like, I can sign it before you leave today.
That'd be
If you'd
great.
like. Yes,
Mr.
sir.
Chairman, thank you very much.
Yes, sir. Thank you for being
Great.
here.
And thank you to the committee.
Thank you. All right, we have one remaining bill on the calendar today, and I'd like to give you a little background because this is different than what the caption might indicate as you look at it. Senate Bill 86 is passed in the Senate, was very similar to Representative Marcus Wiedauer's bill about disclosure for advertisements related to you get in the mail after a corporate registration and solicitations along those lines. That language has all been stripped out of Senator Walker's bill. Senate Bill 86, substitute that you see before you here today, deals with the equitable caregiver statute, which was enacted in 2019. And I was a sponsor of that legislation. Chairman Leader Reeves, who's present here today, was very instrumental in passage of that bill, as well as Chairman Oliver at the time. The legislation that passed was passed very close to crossover day, and after the bill was enacted, there have been certain issues that have been raised, pointed out, that may need to be addressed and corrected in the law. I have brought legislation the two previous sessions to begin to address this, but it unfortunately has not reached ultimate passage. In the interest of making sure the law is corrected and addressed, I'd like to just walk you through this bill briefly and certainly answer any questions, and then I'll recognize Leader Reeves. So first of all, the form that there was a statutory form that was included in the law, and the statutory form is being addressed here with or being updated with changes to the substantive law. But I will also mention that one of the elements rather that has to be met, must be met in order for there to be standing to bring one of these cases, was inadvertently excluded from the law back at the time. So you'll see that line 60 to 62. And so that is a very important element to include, and that is therefore that's being added in, as well as just after it's line 68. There's a fifth blank for the party to write in how that factor is being met. I said factor is an element. It's being met. All right, then the issues that really are remaining here is that, first of all, the third-party custody cases allow for standing in circumstances where, first of all, a parent is unable to care for the child, and that's because the parent's a risk of harm. That could be physical or long-term emotional harm to the child. It's only then the third-party custody circumstance might be considered. But under existing law, prior to the passage of equitable caregiver, it was only a named person within a certain relation of the child. So grandfather, grandparent, great-grandparent, sibling, and uncle, I believe. But that was it. So if you had a step parent circumstance or others who might not fall within that criteria, they could not by law be considered by the court. What this law did is it allowed consideration to be given based upon the perspective of the child and a person who had filled a parent-like relationship. It wasn't done for monetary purposes, that they had an extensive period of contact with a child over a period of time. They could be considered. That was the objective here. But we want to be mindful of the fact that if maybe it's been a great deal of time that has passed since that person was in that role, say more than 5 years, maybe it wouldn't be appropriate for standing. That issue has been something I've been contacted about quite a bit. And I'll actually put the policy question before you all here. But the way this substitute works is the court could only consider such a parent-like relationship if that had occurred within parent-type role that had been fulfilled, if that had occurred within the previous 5 years. So there'd be a certain period of look back. Additionally, what I would submit to you may be very important to the long-term survivability of this statute is at the end, lines 140 to 143, and that is if there is a circumstance where a parent is later ultimately able to become fit and be able to meet the needs of the child, that parent's rights consistent with U.S. constitutional interpretations would supersede. So that would allow the parents' rights to be recognized in the bill. Be happy to answer any questions, and maybe at this point in time, I'll turn it over to Leader Reeves for any input.
Thank you, Mr. Chairman. Thank you for bringing this. And, you know, those of us in the room who have practiced domestic law and have dealt with custody situations, and for Judge Gunner in the room right now, who has seen it from a different perspective. One of the worst things that happens in any courtroom across this country is where everybody in the courtroom knows what would be best for the child under the circumstances that everybody's aware of, but the court's options are limited because of the constraints in our code. And it's devastating. It's devastating, and it's life-altering for these children who end up in the wrong situation because everybody's hands are tied. And this concept that Chairman Evstration led on a few years ago is novel, and it offers a different kind of analysis and a different tool for the judicial body to land in a different place and be able to make a decision that is more in line with the best interest of a child in a particular case. This is extremely important, and perhaps one of the most meaningful things that's come out of this body in the 7 years that I've been here. As a litigator, when you have a custody case and you see the wrong thing happening, there is nothing that interrupts your sleep. There's nothing harder in all of law than when you see that happening, and there's nothing you can do about it. This will continue our efforts to enable the court to be able to make the best decision, and whatever we have to do to refine it, to make sure that it is as sound as it can be, then we need to push full steam ahead to do this, to protect this very important option that we have in our courtrooms. Thank you, Mr. Chairman.
Chairman Gunner.
Thank you, Mr. Chairman. During my time as judge, there were many cases that came before me where I was limited in what I could do. And this statute is another tool in the box, so to speak, to do the right thing for the child that's in front of you. So I think this is a great statute. I think the amendments are very appropriate, and appreciate you bringing this bill.
Thank you. Representative Leverett.
Thank you, Mr. Chairman. I think this does seem like a wonderful, the policy behind this is well considered. But I had a question just about a sort of a nuts and bolts sort of, is the purpose of establishing status as an equitable caregiver to be able to retain physical custody and legal custody of a child when having that rest with the parents is not in the child's best interest?
Yes, sir. And you can even take it. It's a step further. It's only upon a finding that the parents are unfit to care for the child.
Does it say that finding is a condition here anywhere?
Yeah, so it's a predicate condition for standing, which is the fifth element.
Demonstrate the child will suffer physical harm or long-term emotional harm?
Yes, sir.
It says demonstrate the child will suffer physical harm or long-term emotional harm. I'm assuming if the child were to remain in physical custody or legal custody of the parent, that's sort of the unspoken text there.
Yeah, in order to that's right. I think it's unspoken. I will say that also part of the debate at the time was that it's regularly appreciated within the practice that requirement must be proven, and that the court would understand that, the practitioners would understand it.
I think that has been established almost as a constitutional element of denying a parent custody of their own child.
That's
Is that
correct. Yes, sir.
Thank you.
But I take your input as, friendly potential amendment. If you, while we're looking at this here today, I'm not opposed to that discussion. Chairman Oliver. I'll get you next.
I've seen this statute that the two of you are involved in, passed really grant relief and justice to a number of different folks. The language about injury to the child comes out of the history of litigation for grandparents' rights that's gone up and down the Supreme Court, and that's one of the reasons we felt comfortable at the time and feel comfortable today. It's granting custody to a third party other than the biological child is a big deal, and so this has been carefully vetted over time.
Representative Walensky.
Just for clarification, last year I think it was Representative Wilson had a bill that was dealing with in the courts if somebody, the bill you did last year, what is that similar to this bill? Is it the same context where somebody was trying to keep a kid, or if like it was dealing with somebody not in the family trying to take the kid and they were trying to, you don't remember the bill? All right, I'm gonna have to figure out, this bill is similar to bill. I'm trying to figure out which one we did. Okay. Thank you, Chair.
All right, I don't see any questions online. Is there a motion on substitute Senate Bill 86?
Second.
All right, motion to pass in a second. It's LC 480422S. Any further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, passes on to rules. We are adjourned for scheduling purposes. I will notify you if I expect we're going to have a short hearing in the morning to take up Senate Bill 120 as we discussed today. And so if you would just monitor your email 5 to 6 p.m. today, we'll let you know for certain then. Oh, and the Scoggins subcommittee that was set for upon adjournment tomorrow has been canceled. There's no Scoggins subcommittee tomorrow. Thank you. We're adjourned.
I forgot you were
in this committee last year. This is the bill from last year. I forgot you weren't here last year. Is this? No, it wasn't Wilson. It was a different bill that came through.
I was just advocating
But
very
this is a
forcefully
cleanup.
for it.
Yeah, this is a cleanup